Are Title IX charges kept confidential, or will everyone on campus know or hear about it? Attorney Mark A. Satawa explains. Whether or not Title IX charges are kept confidential is another area under Title IX law where there is no simple answer. However, there is a distinction. Initially, a Title IX accusation will be kept confidential. The school will then follow a procedure to investigate the Title IX complaint. Initially, that procedure and the complaint itself will be kept confidential. The complaint will be assigned to a Title IX investigator. Then that Title IX investigator will conduct a preliminary investigation and determine preliminarily whether or not the conduct falls under Title IX and the university's relationship violence policy. The investigator will interview the accusing student, commonly referred to as either the petitioner or the claimant. The accused student is referenced to as the respondent. The investigator will review any collaborating evidence the claimant presents, such as texts, pictures, and social media posts. The investigator may also interview witnesses identified by the claimant. In the overwhelming number of cases, the preliminary determination is made in the affirmative, and the investigator finds that the alleged conduct does fall under the school's relationship violence policy and Title IX, but not always. At that point, when the investigator determines that the conduct does fall under Title IX, the investigator will meet with the accusing student. Again, they will tell the claimant, "We believe these fall under the university's relationship violence policy and Title IX. Do you want to issue a formal complaint?" If the student agrees to issue a formal complaint, they will be told that the complaint can no longer be confidential, and that the student being accused has the due process right to know who is accusing them. Interestingly, if a student, as a result of that, says, "I don't want to go forward, I don't want to file a formal complaint," most schools have a procedure or a vehicle that allows the school to proceed forward against the respondent anyway. If the school goes forward with the formal complaint despite the claimant saying they don't wish to, the obvious twist or nuance becomes whether or not the school will reveal a claimant's identity. It seems clear in most cases involved in Title IX due process would require disclosure of that student's identity, which of course raises FERPA, Federal Education Rights Privacy Act considerations. This is because the claimant is saying, "I don't want a formal complaint filed. I don't want my name out there." The school then decides on its own that the matter is severe or egregious enough that even though the claimant doesn't want us to go forward, they will proceed anyway. The accused student or respondent has the due process right to know who accused them. When you hire Satawa Law, PLLC, you can rest assured knowing your case is in capable and expert hands. We will fight tirelessly in order to defend your rights and protect your future.